Welcome everyone to the deep dive. This is where we take those really complex topics, grab a whole bunch of source material, and really dig in deep to pull out the key insights for you.
Think of it as your shortcut to really getting to grips with the important stuff.
Exactly. Now, before we dive in today, a really crucial note for this specific deep dive. We are focusing squarely on the rights of refugees.
A huge.
Huge. And the material we're exploring, the analysis we're doing, it all comes from resources made available by the University of London for their students. So we want to be absolutely clear up front. This is purely for educational purposes,
Mhm.
designed specifically to help you, our listeners, understand this complex material thoroughly.
Absolutely. And we should also mention this deep dive is proudly brought to you by Sinorbit Academy, Sri Lanka.
That's right.
And on that note, we really want to extend our very best wishes and good luck to all of you out there, particularly anyone facing exams soon. We genuinely hope this detailed look at the source material is helpful for your studies.
We really do. Okay, so our mission today, we're unpacking this absolutely fascinating, but let's face it, intensely political and complex subject.
Definitely. And
The rights of refugees, it raises these fundamental questions. What happens internationally when a state, a country, just fundamentally fails to protect its own people? Who steps up? Who has the responsibility?
big questions.
Massive. We'll be using excerpts from a key document on refugee rights as our guide. We're going to cover, well, everything from the deep historical roots.
Which go back further than you might think.
Right. Then the core legal framework, that's the 1951 Convention and its protocol, we'll get into those, key definitions, and crucially, how courts have actually interpreted those definitions over time.
Because the interpretation is everything, really.
It is, and obligations involved, some broader challenges like the situation of internally displaced persons, people often overlooked, and the specific concerns relating to women and girls.
And you should get ready for this because, well, it's, academic material. It's also packed with surprising facts, some really difficult realities, and genuinely controversial aspects.
It's not just dry law, then.
Not at all. We'll look at historical resistance to even the idea of protecting refugees, which is quite something. The inherent difficulty in pinning down crucial legal terms like persecution or well-founded fear.
They sound simple, but they're not.
Far from it. And then we'll see how these concepts are actually applied or sometimes, hotly debated in real court cases that have shaped the law we have today.
Okay, let's just jump straight in. It feels like when we see images of refugee crises now, it's all very contemporary, very current events. But the basic human act of fleeing persecution, fleeing conflict, seeking sanctuary somewhere else, that's ancient, isn't it?
Oh, absolutely. You've hit on something really crucial there. It's not a modern problem. It's woven right through human history.
Yeah.
The source material we're looking at points to examples stretching back millennia.
Millennia, like what?
Well, you find narratives, whether you see them as historical accounts or foundational stories, like in the book of Exodus, a core text in Abrahamic faiths. It describes suffering, flight from oppression, the search for a safe place. It reflects that ancient reality.
Okay.
And even figures we think about differently, like, say, some of the founding fathers of the USA. In a way, they were seeking sanctuary from political or religious pressures back in Europe.
Right, fleeing their home country because of beliefs or opinions. Makes sense.
Exactly. And look at more recent history, the 19th and 20th centuries. The persecution and flight of Jewish populations escaping pogroms across Central and Eastern Europe is another stark example.
Yeah.
And then, on a scale that's almost unimaginable, the partition of India in 1947. While it was complex, involving more than just what we'd now strictly call convention refugees, it resulted in arguably the biggest mass movement of people in human history, a consequence of profound political upheaval leading to just tragic displacement.
So this incredibly long history, it connects directly to that core human rights idea we keep coming back to. What happens legally, morally, practically when that basic protection a state owes its people just falls apart?
Precisely. If that fabric of human rights protection within a state just collapses, maybe because the state itself is the persecutor, or maybe because it completely fails to protect its citizens from others, well, the consequences for the individuals caught up in that are profound.
They need protection from whatever is happening.
Exactly. They need protection from that abuse, that conflict. And that is precisely where refugee law tries to step in. That protection might be provided by third states, other countries, but this is key. It depends on the individual managing to actually reach their border and successfully seek sanctuary.
Which we legally call asylum.
Asylum, yes. And that specific aspect, the need for protection by a third state offering asylum, that's really our focus today based on this material.
And the source material is careful to distinguish this from something else, extraterritorial obligations.
Yes, it mentions that briefly. Extraterritorial obligations.
Hmm.
That's about whether a state's human rights duties apply outside its own borders, maybe if it's involved militarily in another country, or has effective control somewhere else.
Okay, different topic.
It's a very complex area, lots of difficult court cases, but yeah, not our focus today. But you're right to flag it. In a way, refugee protection and extraterritorial obligations are maybe two sides of the same coin, both dealing with situations where someone's own state isn't giving them the protection they need.
It really strikes me, though, despite this ancient history, this clear human need, there seems to be this constant underlying political resistance,
Yeah.
to helping people who arrive asking for help. The source calls refugee law intensely political, noting states resist open-ended responsibility, even with UN attempts to create a framework.
That resistance is fundamental to understanding how the law evolved and why it's still so contentious. For a long time, dealing with displaced people was very ad hoc, case by case, or very focused on Europe, especially after the World Wars.
Right.
But in recent decades, refugee movements have become truly global. And the source highlights countries that have taken on an enormous burden of hosting refugees, often countries that don't have huge resources themselves.
Which countries are key examples here?
Well, for many years, Pakistan and Iran hosted the largest populations globally, mainly Afghans fleeing decades of conflict. Looking at the figures cited for the end of 2019, Turkey hosted more refugees than any other country worldwide, mostly Syrians escaping that devastating civil war.
Wow.
And in Africa, the Great Lakes region has seen millions displaced by long conflicts involving places like the DRC, Uganda, Rwanda, Burundi.
And even in those countries, the source says hosting refugees has been controversial. There's pressure for people to return.
Tragically, yes.
Yeah.
Look at the Afghan population in Pakistan. Millions have lived there for decades, some since the Soviet invasion back in the late 70s. But there's been growing pressure recently for them to return, often called voluntary repatriation, but happening under very difficult circumstances. The source uses a very poignant example, Sharbat Gula. Remember her? The world-famous Afghan girl from that iconic 1985 National Geographic cover.
Oh, yes, of course.
She became this global symbol of Afghan suffering under Soviet occupation. Well, in 2016, after living almost her whole life in Pakistan, she was arrested and expelled, forcibly sent back to Afghanistan, apparently due to issues with her ID card. Her story and the sort of public clamor for her expulsion at the time really highlights the complex political tensions around hosting large, long-term refugee populations.
That story just underscores the human cost, doesn't it? The individual tragedies wrapped up in these huge global events, and we see these tragedies all the time.
Sadly, yes. The source reminds us of images just seared into our minds, like the photo of Aylan Kurdi, the 3-year-old Syrian boy whose body washed up on a Turkish beach in 2015.
I remember that picture. Horrific.
Horrific. That image did for a while seem to stir European consciences about the Syrian tragedy. But countless others, just unimaginable numbers, have died trying to reach safety, whether crossing the Mediterranean in these incredibly dangerous boats or trekking across brutal land routes, facing abuse, exploitation.
And despite these heart-wrenching stories, the general attitude from many countries, potential destinations, or even transit countries seems to be, as the source puts it, extremely hostile.
That's probably a fair description for many states. This hostility comes from potential destination states, countries people hope to reach, like, Norway, Germany, France, the UK, but also from transit states that people have to pass through, like Greece, Hungary, the Czech Republic.
Though Germany was an exception for a bit.
Yes, the source notes Germany was a notable exception for a specific period, roughly 2014 to 2016, when it agreed to host an additional million Syrians. That really stood out globally as an act of solidarity. But overall, the political climate in many desired destination countries is often, well, openly unwelcoming.
And this is where seeking asylum gets tangled up, often deliberately, with wider debates about immigration, right?
Exactly. In almost all developed nations, the discussion around asylum seekers, their treatment, their fate, has become deeply intertwined with public and political views on immigration generally and economic migrants specifically. The source points to two related issues here: racism and Islamophobia. They're distinct, but they often overlap in these heated debates. Immigration, by its nature, brings people seen as outsiders into a society. Even if racially similar, they might be culturally, linguistically, nationally different.
Which can cause friction.
It can generate opposition, yes. But the source argues this opposition gets massively amplified by the perception of competition for scarce resources, things like housing, school places, jobs.
And this isn't just a modern thing either. The source gives historical examples of anti-immigrant feelings in the UK going back centuries.
It goes way back. For instance, King Edward I expelled all Jews from England in the 13th century, partly fueled by local resentment. Much later, the British Aliens Act, 1905, arguably the first real piece of immigration law anywhere in the world.
What was that aimed at?
It was specifically designed to control the flow of people from Europe, notably targeting Jewish immigrants seeking sanctuary from persecution in Central and Eastern Europe at the time. And the source reminds us now, all nation-states impose immigration controls. It's universal.
Bringing it right up to today's politics, this feels like a constant hot-button issue, always near the top of the agenda.
Absolutely. The source points to really recent prominent examples. The UK's 2016 Brexit referendum, immigration, was central for many voters, even integration from within the EU, let alone further afield. And in the US, the 2016 election and the Trump presidency, immigration was a defining theme, with specific groups like Mexicans and Muslims explicitly targeted in political rhetoric. And Islamophobia, particularly relevant in non-Muslim majority states receiving asylum seekers, clearly feeds into these broader debates. It connects to anxieties about multiculturalism, distrust linked to geopolitics, perceived lack of integration, and yes, racism, especially since a significant number of asylum seekers in developed states are Muslim.
So it seems when states tighten up other ways for people to enter for work, family, study, then seeking asylum under the Refugee Convention can sometimes look like the main, maybe even the only way in, which leads to this perception, often from politicians, that the asylum system is a soft underbelly of immigration rules.
That's precisely the argument you hear constantly, because states have really clamped down on regular immigration routes. Claiming asylum under the convention framework is sometimes seen, often unfairly, as an easier path to entry and maybe permanent status.
And that fuels criticism of the convention itself.
Yes, widespread criticism. The source gives an early example. The UK's Home Secretary back in 2001, Jack Straw, argued the convention needed revising because he felt economic migrants were using it to bypass immigration controls. That was fairly novel then, but the source says sadly it's become routine political rhetoric in many countries today.
It's undeniable there's this huge, complicated political backdrop. Centuries of history, profound human tragedy, modern tensions around identity, resources, security. It's a lot.
Yeah.
But to even understand the debates, you need to understand the actual legal tools designed to offer protection,
Exactly, and that brings us right to the core legal foundations.
which are the 1951 Convention relating to the status of refugees and the later 1967 Protocol.
That's right. The source walks us through the post-World War II context. You had organizations like UNRA and IRO dealing with millions of displaced people, mainly in Europe. But there wasn't a single coherent body of international law for refugees.
Just piecemeal agreements.
Pretty much. There were earlier treaties, 1933, 1938, but they were limited, often for specific groups and not always effective.
So how did we get from that to a more structured global system?
Well, the international community, through the UN, saw the need for a more universal approach. This led to creating the Office of the UN High Commissioner for Refugees, UNHCR, in 1950. Crucially, UNHCR got a global remit for refugee protection.
Okay.
Then, just a year later, the Refugee Convention 1951 was adopted. The main goal was to set up a general definition of who counts as a refugee, applicable beyond specific groups, and outline the rights and duties of states towards them. A massive step forward. Let's repeat that name. Refugee Convention 1951.
But I gather there were some major compromises during the drafting. States were hesitant about signing a blank check.
Absolutely. States back then were understandably reluctant to commit to obligations that felt too broad or unlimited. They worried about infringing on sovereignty, creating indefinite burdens. And you see this reluctance right in the original convention definition. It originally only applied to people who became refugees as a result of events occurring before 1st January 1951. And it let states choose to limit it geographically just to events happening in Europe.
So time-limited and potentially Europe only.
Exactly. Those two limits, temporal and geographical, were direct results of states not wanting an unlimited ongoing responsibility, especially as global travel was increasing.
So how did the convention become relevant to crises happening after 1951 all over the world?
That's where the 1967 Protocol comes in. Its key function, its main job, was to remove both that 1951 date limit and the geographical option. So for states that signed up to the protocol, which is the vast majority, the convention effectively applies to refugee situations whenever and wherever they happen. The 1967 protocol also added an important duty for signatory states. They have to cooperate with the UN, specifically UNHCR. They agreed to give UNHCR statistical data on refugees in their country and report on how they're implementing the convention and their own relevant laws. So, repeat those names. The Refugee Convention 1951 and the 1967 Protocol. They're the bedrock, together.
Okay, convention defines refugees and rights. Protocol makes it global and ongoing. What's the single most fundamental principle in the convention? The one rule states absolutely cannot break.
That would have to be the principle of non-refoulement. It's absolutely central. Non-refoulement means basically a state must not expel or return a refugee to a country or territory where their life or freedom would be threatened because of one of the convention reasons. Repeat that term, refoulement. That's the act of sending someone back into danger.
Was that easily accepted back in 1951? It seems like a major point of tension today.
No, it was contentious then. And it still is. States worried about being forced to let unlimited numbers stay once they cross the border. This fear still drives states to try and stop people reaching their territory in the first place.
How do they do that?
Well, the source gives a clear example. The UK's Immigration and Asylum Act, 1999. This law hits transport companies, airlines, ferry operators, train companies with heavy fines, up to £2,000 per passenger, if they bring someone to the UK without the right documents or permission.
So instead of stopping people at the border, they try to stop them getting to the border by penalizing the carriers.
Precisely. It shifts the burden of immigration control onto transport companies. But the source points out a major, often tragic consequence. It pushes people seeking asylum, and also economic migrants, towards dangerous, unregulated people smuggling networks.
Making the journey much riskier.
Hugely riskier, exposing them to exploitation, abuse, injury, even death.
It makes sense that states have obligations under the treaty. Does the convention put any duties on the refugees themselves?
Yes, it does. Maybe less discussed, and definitely harder to enforce internationally against individuals, but Article 2 says every refugee has duties to the country they're in.
Like what?
Things like conforming to the laws and regulations of the host country, respecting measures taken for public order. It shows the relationship isn't entirely one-sided. There's an expectation of lawful behavior from refugees, too. And maybe just quickly add, as the source notes, while the 1951 Convention and 1967 Protocol are the main global ones, there are other regional agreements on refugees and asylum. The source lists examples from Latin America, treaties going back to 1889, specific conventions on asylum from the early 20th century. So regional cooperation can also play a part.
Okay, so we have the history, UNHCR's creation, the 1951 Convention setting the framework, the 1967 Protocol making it global. Now, let's get to the absolute heart of it, the definition in Article 1. Who is a refugee?
Exactly. This definition is the gatekeeper. Article 1 builds on earlier definitions, grandfathering in people covered by previous agreements. But the key part for new situations is Article 1-2.
Right, let's really break down Article 1-2. What are the essential bits someone has to meet to be a convention refugee? We need to be crystal clear on these.
Okay, let's list them and repeat the crucial terms. A refugee is someone who, firstly, as a result of events before January 1951, and again, the protocol removed this date from most states, but it's in the original text, is located outside the country of his nationality, or their former home if they're stateless.
Outside their country.
And they're outside owing to a well-founded fear.
A well-founded fear.
They're being persecuted.
Persecuted.
And that persecution must be for reasons of race, religion, nationality, membership of a particular social group, or political opinion. Let's say those 5 reasons again. Race, religion, nationality, membership of a particular social group, or political opinion.
The 5 grounds. Got it.
And finally, because of that fear, they're unable or unwilling to avail himself of the protection of that country, or unwilling to return home if stateless.
That is a dense definition. Lots of key terms. Let's tackle the first big one, well-founded fear. The source calls the convention's approach individualistic. What does that mean?
It means the assessment isn't just about the general situation in a country. It's tailored to the individual's specific circumstances. It needs both a subjective element, what the person actually fears, their personal story, experiences, how they see things, and, crucially, an objective element.
Objective.
Yes, the fear has to be well-founded. There must be objective, verifiable reasons for that fear. This means looking at credible external information about the situation in their home country.
So it's not enough just to say you're scared. There has to be evidence that the fear is reasonable, likely.
Exactly. The source mentions the UNHCR handbook, which clarifies this two-part test. First, is the person genuinely afraid? That's subjective, relies heavily on their credibility, their story. Second, is that fear well-founded objectively? That needs external evidence, human rights reports, government information, news, expert testimony.
Credibility is key, then.
Absolutely key for the subjective part. You have to look carefully at everything they say, their background, affiliations, past experiences. See if it hangs together, if it matches what's known about the country. You're not judging the country politically, but you must consider their statements in the context of the verified situation there. Knowing that situation, what they or their family experienced, the laws, how they're applied, it's all vital evidence.
But this is usually individual, right? What about huge numbers fleeing at once?
Good point. In mass displacement situations, think huge numbers fleeing war. You just can't do individual interviews for everyone.
Yeah.
So often a group determination is made,
Meaning?
meaning each member of the group is regarded prima facie, on the face of it, presumed as a refugee, unless there's specific evidence otherwise for an individual in that group. It's a necessary practical step in big crises.
Okay, second term. Persecution. How's that defined? Is it just being arrested?
No, definitely not. The source is really clear. Persecution is not the same as prosecution for a crime. It's much more serious. It's linked to violations of fundamental civil and political rights.
And not just any violation.
Right, there's a sort of hierarchy. A threat to life, torture, slavery, violations of the most fundamental rights. Those are very likely persecution. A threat to freedom of expression. Less severe than torture, maybe serious enough, but less likely. Violation of the right to work. Even less likely to count as persecution under the convention. So, repeat this. The more fundamental the civil or political right being violated, the more likely it is persecution.
Does someone have to have actually been tortured or jailed already, or is it about the risk?
It's about the risk of it happening in the future.
Hmm.
Past experiences are strong evidence, if you were persecuted before. It suggests future risk, but not conclusive alone. The difficulty is huge because you're predicting future risk.
How likely does the risk have to be?
That's the million-dollar question.
Yeah.
Is it beyond reasonable doubt? Balance of probabilities. A lower chance, like the 20% the source mentions, just to illustrate the difficulty. It shows how hard these decisions are and errors can happen. Ultimately, it comes down to the individual circumstances, the facts, and their credibility.
And finally, the persecution has to be for one of those 5 reasons: race, religion, nationality, membership of a particular social group, or political opinion. The source says membership of a particular social group has been the trickiest one for courts.
Yes, absolutely. The other grounds, while sometimes complex to apply, are generally easier to grasp conceptually. But defining membership of a particular social group, that's caused major legal headaches and different interpretations globally.
Why is it so difficult?
Well, it's inherently vague, and its interpretation has evolved significantly, linking to that idea of a living instrument in human rights law, where treaties are interpreted in light of today's understanding, not just 1951's understanding.
Now, understanding how courts have grappled with these terms in real cases is vital then. Let's look at the English courts as an example.
Yes, the case law really brings these abstract terms to life. The source highlights some key English decisions.
Okay, starting with well-founded fear. What's the main case?
The leading English case, very influential globally, is R.V. Secretary of State for the Home Department, Ex parte Sivakumaran, from 1988. Let's repeat that, Sivakumaran. Lord Keith's judgment in the House of Lords is seen as particularly helpful.
What did Sivakumaran decide?
The House of Lords said determining well-founded fear is fundamentally an objective test. You look at the real situation in the applicant's country. And critically, the applicant has to show a reasonable degree of likelihood of persecution if returned. That's considered quite a stringent test. Repeat it. Reasonable degree of likelihood.
And was that different from lower courts?
Yes. The Court of Appeal in the same case had suggested a less stringent test, but the House of Lords went with a stricter reasonable degree of likelihood.
Okay. What about the standard of proof needed for that? How certain do they need to be?
That specific point was looked at more in Karunakaran v. Secretary of State for the Home Department in 2000. Repeat, Karunakaran. Reading Sivakumaran and Karunakaran together, the key takeaway is that determining refugee status is an inquiry into evidence, an overall evaluation. It's not like a criminal trial needing proof beyond reasonable doubt.
Or like weighing everything up.
Exactly. Evaluating all the evidence, keeping the convention's protective purpose in mind, not just demanding rigid proof.
Right. Now, persecution. The source points to a more recent UK Supreme Court case.
Yes, HA Iran and HT Cameroon v. Secretary of State for the Home Department from 2010. Repeat, HA Iran and HT Cameroon. Lord Rogers' judgment is seen as very thorough. This case tackled some really difficult questions, such as, can persecution come from private individuals' family, non-state groups, not just the state? The court said yes, it can, but only if the state fails to provide effective protection. If the state can't or won't protect you from private persecution, that counts.
And it also dealt with that incredibly difficult situation. If someone could avoid persecution by hiding who they are, like concealing their sexual orientation, does that mean they don't need protection?
A profoundly important point. And the court's reasoning in HJ Iran and HT Cameroon was critical. They decisively said the fear is well-founded if the person cannot live freely according to their identity or beliefs without fear.
So just because you could hide doesn't mean you don't need protection.
Exactly. The court said people shouldn't be forced to choose between persecution and hiding a fundamental part of who they are. It strongly affirmed the right to live openly without fear, a major development.
Okay, finally, let's circle back to that trickiest category. Membership of a particular social group. Which English case is key?
The source highlights RV Immigration Appeal Tribunal and another, Ex parte Shah, Islam, and others v. Secretary of State for the Home Department from 1999. Calls it a fascinating case that led to major change in UK law and policy on female asylum seekers and influenced other countries too. Repeat the names: Shah, Islam. Lord Stein's judgment is particularly important.
How did it change things?
It's a prime example of that living instrument idea. The House of Lords interpreted a particular social group in a way that could include groups like women facing gender-specific violence, even if the 1951 drafters hadn't explicitly thought of that specific group.
And this caused a political backlash.
Oh, massively. The source mentions wide-scale outrage politically in the UK. The Home Secretary at the time, Jack Straw, publicly slammed the decision and even called for the Refugee Convention itself to be reformed.
Wow. Shows how political this gets.
Absolutely. It perfectly illustrates the tension. The source asks you to think, was this interpretation foreseeable? Is it fair on states? Does it open the door to abuse, as critics claim? These questions are still central to the debate today.
Okay, so we've dug into the definition in Article 1, unpacked terms like well-founded fear, persecution, particular social group, and seen how courts, via cases like Sivakumaran, Karunakaran, HJ, Iran, and HT, Cameroon, and Shah, Islam, interpret them. Now, let's switch focus completely to the actual rights and duties the Convention sets out for recognized refugees in Chapters 2 to 6. Article 1 says who qualifies. These chapters say what states must do for them.
Right. Once someone is recognized as a Convention refugee, the state they're in has specific obligations. It's about giving them legal status and letting them live safely and with dignity.
Let's group these. Chapter 2 is about legal standing.
Yes, Chapter 2, juridical status. Articles 12 to 16 cover various legal rights. The main idea is giving refugees a recognized place in the legal system. Article 12 deals with personal status, like marriage rights governed by the host country's law. Articles 13, 15, 16 cover property rights, contract law, right of association, like joining trade unions, and crucially, free access to courts.
What's the standard for these rights, same as citizens?
Generally, for many of these, the standard is treatment at least as favorable as that given to other lawfully resident aliens or foreign nationals. So, similar to other legal foreigners, but not necessarily instant equality with citizens. The key is formal legal existence and access to justice.
And Chapter 3 covers employment rights. Can refugees work?
Yes, Chapter 3, Articles 17-19. For wage-earning jobs, Article 17, states must offer refugees the most favorable treatment they give other foreign nationals. But states can still have restrictions to protect their own job market.
Oh, okay.
But there are exemptions. Restrictions shouldn't apply if a refugee has lived there 3 years or has a spouse or child who's a national. And Article 7.3 actually encourages states to give sympathetic consideration to making refugee work rights the same as nationals. For self-employment, Article 18, and professions like doctors or lawyers, Article 19 if qualifications are recognized, the standard is generally at least as favorable as aliens generally. So, access comparable to other foreigners, hopefully improving over time.
Moving to Chapter 4, welfare and social rights. Housing, education, support.
Chapter 4, Articles 20-24. Here the standard varies. For basics like rationing systems, Article 20, elementary education, Article 22, and public relief or basic welfare, Article 23, refugees should get the same rights as nationals.
Okay, parity for basics.
Yes. For housing, Article 21, and other education, Article 22, it's treated as favorably as possible, but no less than lawfully resident aliens. Article 24 covers labor laws and Social Security, same protection as nationals where covered by law. But it notes that for things like pensions that you build up over time, there might be differences based on contribution history. So essential support often matches citizens, with some variation for non-basics or contributory schemes.
Chapter 5 seems critical admin stuff, expulsion, and that key principle again.
It is. Chapter 5, Administrative Measures, Expulsion, Refoulement. Article 25 is vital. It tackles the problem of refugees lacking documents from home. Host states must help them get necessary papers a refugee can't get otherwise, stops them being legal ghosts.
Important. What else?
Articles 26-28 cover freedom of movement. Article 26 gives refugees the right to move freely within the host country. Article 27 says states should issue ID papers for internal travel. Article 28 requires states to issue travel documents like a refugee passport so they can travel outside the country, unless there are serious national security reasons.
What if someone enters illegally because they had to flee?
Article 31 covers that. It's a key protection. States can't penalize refugees just for illegal entry or presence if they report promptly, had good cause, like life freedom threatened, and actually are refugees under Article 1. It recognizes people fleeing persecution often can't use legal channels.
And Article 32 on expulsion?
Yes. A refugee lawfully present can only be expelled for national security or public order reasons, and there must be due process they get to present evidence, appeal, have representation. Plus, the state must give them a reasonable time to try and find another country to go to. Important safeguards.
And then the big one, Article 33, non-refoulement.
Yes. Article 33, arguably the most fundamental. The absolute prohibition on returning a refugee to any place where their life or freedom would be threatened for one of the 5 convention reasons. It's considered non-derogable, can't be suspended.
Is there any exception?
A very narrow one in Article 332. The protection doesn't apply if the refugee is a threat to national security or has been convicted of a particularly serious crime and is a danger to the community. It's a very high bar, showing how vital non-refoulement is. And Article 34 encourages states to help refugees naturalize and integrate.
Finally, Chapter 6, Article 35 is about cooperation.
Straightforward, but important. States must cooperate with UNHCR. They have to provide reports on refugees and how they're applying the convention, and tell the UN Secretary General about their national laws implementing it. Sets up international oversight.
That's a really comprehensive set of rights and duties, but the source makes a critical point. The convention protects a specific group, those who've crossed a border, but millions more are displaced without leaving their country.
A crucial distinction, and the source really highlights it with the numbers. While the 1951 Convention protects those who meet the Article 1 definition and are outside their country, vast numbers globally are forced from home by conflict, disaster, persecution, but haven't crossed an international border. They're displaced within their own country.
And these people are called
Internally displaced persons, or IDPs. Let's repeat that, IDPs. The source uses the definition from the 1998 UN Guiding Principles. Persons or groups of persons who've been forced or obliged to flee their homes and who have not crossed an internationally recognized state border. That last part is key, not crossed an international border.
Do IDPs have a specific international legal protection like refugees?
This is the fundamental difference.
Mhm.
IDPs are still under the jurisdiction and responsibility of their own government. International law doesn't automatically step in just because they're internally displaced.
So no specific treaty for them?
No specific treaty, just for IDPs, like the Refugee Convention. They were protected by existing human rights treaties their state signed and by humanitarian law in conflict, but no dedicated IDP legal regime.
The source mentioned the 1998 UN Guiding Principles on internal displacement.
Yes, they were developed to clarify states' existing obligations toward IDPs. Widely accepted as guidance, but important. They are not legally binding like a treaty.
What are the main challenges for IDPs compared to refugees then?
The biggest challenge is that being displaced internally creates huge physical, logistical, administrative barriers to getting their rights met. Think about finding shelter, food, water, healthcare when you're constantly moving within your own country, often without papers, property, or access to helpful authorities. The displacement itself makes accessing rights incredibly hard.
Looking at the global numbers really puts this in perspective, the scale, the difference between refugees and IDPs.
The statistics cited, mostly end of 2019, are staggering. Around 26 million refugees worldwide, up from 21 million in 2016. Another 4 million asylum seekers waiting for decisions. But IDPs displaced inside their own countries, around 42 million, that's way more.
42 million IDPs.
Lean those down from a peak of 65 meters in 2016, it's still enormous. Plus about 10 million stateless people. All told, almost 82 million forcibly displaced people globally. Let's repeat that. Almost 82 million people forcibly displaced.
Just unbelievable numbers. And is the burden of hosting refugees shared fairly among countries based on wealth or size?
Absolutely not. That's a key point the source stresses. It's not spread evenly or by ability to cope. Proximity to conflict is often the biggest factor. Look at 2019. Turkey hosted almost 4 million, mostly Syrians. Pakistan, 1.4 million.
Big numbers, but maybe manageable for big
Well,
countries.
consider the proportionate impact. Pakistan's 1.4 million refugees were less than 1% of its huge population. But look at Lebanon in 2016. Hosted about 1.1 million refugees in a country with under 6 million people total. That meant 1 person in 5 in Lebanon was a refugee.
1 in 5. The strain must be immense.
Immense demographic, social, economic impacts. So, the crucial takeaway from the numbers. IDPs far, far outnumber convention refugees. Internal displacement is the bigger phenomenon numerically.
Within these huge displaced populations, are there specific groups facing particular risks? The source focuses on women and girls.
Yes, absolutely. Women and girls make up a huge proportion and face specific, often horrific dangers. The stats have been consistent for over 20 years. Nearly half the world's refugees are female. Mass movements are often about 50-50, though individual asylum claims in developed countries might skew male.
And children.
Over half of all refugees are under 18, over 10% under 5. Though the source notes data often comes from the developing world where most refugees are.
What makes refugee women and girls especially vulnerable?
Well, they face problems common to women everywhere, violence, discrimination, but it's dramatically worsened by their situation. Fleeing persecution, the chaos of flight, being cut off from family and community protection, being foreigners in a strange place, maybe not speaking the language.
It multiplies the risks.
Exactly. The source details measures try to address gender-specific violence and abuse. Things like ensuring women claiming asylum based on sexual violence are interviewed by female officers, providing counseling, encouraging women's associations, including women in planning camps.
Practical things.
Very practical. Sensitive camp layout for safety, prioritizing women's and girls' needs for education, health, safe access to food and water. The source even mentions horrifying cases of women forced into providing sexual favors for basic supplies.
Has this recognition changed how asylum claims are handled?
Yes, UNHCR guidance, plus landmark cases like Islam and Shah. Let's repeat that name, Islam and Shah, which was so vital for interpreting particular social group to include women facing gender violence. This has pushed states to adopt specific guidance for female asylum seekers, trying to ensure their specific risks are properly assessed.
What about families? Is there anything about keeping families together?
The 1951 Convention text itself didn't explicitly include a right to family reunification, but the final act of the conference that adopted it did address it.
How?
It strongly called on governments to protect the refugee's family, especially ensuring unity, meaning if the head of the family gets refugee status, dependents should too. It also stressed protecting unaccompanied minors, kids traveling alone, appointing guardians, helping with adoption if needed. That principle of family unity is now widely implemented by most states.
And unaccompanied minors, children traveling alone, that seems like a growing issue.
It is, sadly, a significant concern. Families increasingly risk sending children, often boys, on these incredibly long, dangerous journeys alone, hoping they'll find safety. The source gives a UK example. Over 2,000 asylum claims from unaccompanied children in the year ending 2015.
That's a lot.
A near 50% increase on the previous year, almost 10% of all UK asylum claims then. The source notes the UK and most European states do grant asylum to these children if they arrive and meet the criteria.
This has been incredibly detailed. We've covered the history, politics, law, the definitions, key terms, court cases, rights, duties, IDPs, vulnerable groups.
We have. And for anyone studying this, the key is seeing how it all connects. Understanding Article 1's definition, knowing how terms are interpreted through cases like Sivakamaran, Karanakara NHJ, Iran NHT Cameroon, and Shah, Islam, grasping the rights in the later chapters, the context of IDPs, vulnerable groups. It's all crucial for getting the whole picture, and hopefully helps you feel ready for assessments.
To maybe just make it more concrete, let's briefly touch on how you'd apply these concepts. Say, if you had to evaluate an asylum claim, even a hypothetical one like the scenario in the source material, we won't solve it, obviously, but just walk through the process.
Good idea. When faced with a case, real or hypothetical, you break down the individual's story. Identify the country they fled, the country they're in. Check the relevant treaties, 1951 Convention Protocol, maybe human rights treaties like the European Convention on Human Rights, the
Hmm.
ECHR. Then, for each person, you systematically apply the Article 1 criteria. Is there a well-founded fear? Is it of persecution? Is it for a convention reason? Race, religion, nationality, social group, political opinion? Are they unwilling to return?
And you link this directly to the cases we discussed.
Exactly. Assessing well-founded fear. Think Sevekuman, Karanakar, and the standard of proof. Defining persecution, including from non-state actors if the state fails to protect, and that living freely idea. Apply HJ, Iran, and HT, Cameroon, claims based on gender violence. Look at how membership of a particular social group was interpreted in Islam and Shah. Political activity, political opinion, or social group grounds.
And you mentioned the ECHR.
Yes, Article 3, prohibition of torture, inhuman or degrading treatment. It's a backstop. Even if asylum under the convention is refused, you still have to ask. Would sending them back expose them to a real risk of Article 3 violations? Think parallels to big ECHR cases like Soring, Chahal, Saudi on risks like death penalty or severe mistreatment upon return. The process is meticulously applying the legal criteria and their interpretations from case law to the specific facts. It's complex work.
This deep dive, drawing on the University of London's material, has really covered all the key areas outlined, hasn't it? The political-social context, the legal-theoretical issues, the convention summary, the problems in applying the definition, the focus on women, girls, families, and how English courts have interpreted the law.
I think we've touched on all those essential elements. And for anyone wanting to go even deeper, the source suggests further reading scholars like Kajarum Hathaway. Their work often explores those broader themes, the tension between state interests and human rights, and even asks we need to rethink the whole framework, maybe focus less on just accommodating refugees who arrive, and more on tackling the root causes of why people flee in the first place.
It's so clear this topic is far from settled, legally or politically. We've unpacked a huge amount today, acknowledging the complexity, the profound human stakes involved in refugee rights and protection.
And while the 1951 Convention and its 1967 Protocol give us that vital international framework, actually applying the definitions, ensuring principles like non-refoulement are upheld, navigating the legal and political minefields, it remains a constant struggle, especially with rising global displacement and so many, as we saw, who are IDPs and don't even fit the strict convention definition.
We really hope this deep dive into the source material has been valuable for you, shed some light, maybe helped you feel a bit more prepared for studies or exams. Thank you so much for joining us.
Thank you.
And as you go about your day, maybe mull this over. Given the ancient history of seeking sanctuary, the specific 1951 definition, the political resistance states often show, and the reality of tens of millions of IDPs who don't fit that definition, is our current international framework for protecting the forcibly displaced truly fit for purpose in the 21st century? Or does it, as some argue, need a fundamental rethink?
Definitely something significant to think about.
Absolutely. Keep exploring, keep questioning, keep learning. Join us next time for another deep dive.